Well, hello to all of my methodical researchers out there. Our topic today is updating cases to ensure that they are still legally valid. We will also cover how to use Shepherd's and how to use Quick Check on your brief or your memo on your finished product to accomplish this for all of your primary sources at once. Amazing. This is this updating process that we just absolutely have to get into the habit of doing consistently. It really is a critical skill. We definitely do not want to go before a court with some case in our hand that just seems absolutely fantastic for our client, only to find out at the last minute that it's been overruled. That would be bad. That would make us look bad. Fortunately for us, it's just not that hard. It's not that terribly different from what we saw with codified law that we only did, a short time ago. The main difference you'll see is really that for cases, you're usually going to run into more flags and more signals, more potential issues than you would with statutes. And that's because each case is just a lot more likely to combine, just a ton of different and otherwise perhaps even unrelated issues. It's just got more stuff in it. So there are more potential issues with all of those issues that it contains that need to be flagged. However, conversely, there's also a much greater likelihood that any single one of those flags or signals just won't be relevant at all to the particular issue that you are researching. This means that you really have to put on your analysis hat and ask yourself whether the fact that this case was overruled on issue A affects the court's holding on issue B as it relates to your research. Now, another important distinction from updating statutes, it's a little simpler to think about and articulate, is that there's no aspect of currentness to watch out for. A case might be overruled by another case, but we know that the case that we found itself, isn't going to change while we're not looking at it. So we don't need to be concerned with that. So let's check out an example. Let's look at Richardson v. Henley, Georgia case that we found in an earlier video on preliminary analysis, I think it was. In this case, it has a few different holdings. We can see them if we look at our head notes here. But for our legal issue, really the one that we're interested in is it's holding that secondary smoke from this pipe could conceivably be actionable as a battery, could be the tort of battery. But when we pulled up Richardson v. Henley in Westlaw, we did notice for sure this super ominous looking red key site flag. I mean, that can't be good. Telling us that the judgment for this case was vacated. Uh-oh. So yeah, we definitely need to know more about this, right? And to find out more, we can just click on the key site flag. You can click on that flag to get a rundown of the negative treatment of this case. And really our negative direct history, that is our chief concern here. This tells us if a later court, usually like a higher court acting in a supervisory role, reviewed this same case and took some action that reflects upon the case negatively, it may have negative consequences for the case as a source. This includes actions like reversing a case, which is what we see here. It looks like Henley v. Richardson reversed the judgment of Richardson v. Henley, right? So when we run into things like this, we need to ask ourselves, does the ground upon which the case was reversed, does the reason for its reversal, does that affect the holding for the issue that we care about? The holding stating that secondhand smoke can constitute a battery? Is the ground of reversal relevant to that holding? That's what we need to know. And this means, of course, that we'll have to read and analyze these later cases that gave the case that we want to use the negative treatment. And when we do that, when we look at this Henley v. Richardson case, it looks like it was reversed because the purported battery occurred in a workplace. And the Georgia Supreme Court decided that workers' compensation here would be the exclusive remedy, which means that a battery claim would just be unavailable. And then after that, it looks like, if we look at our subsequent history, or negative direct history, it looks like after the judgment was reversed, it went back to the Court of Appeals so they could vacate the original judgment for the plaintiff, or for the appellant, So our question here really is, does the reversal by the Supreme Court of Georgia, does that affect our holding on whether the pipe smoke constitutes a battery? And we've got to say that, yes, the original court's holding that workers' comp was not the exclusive remedy was basically a conditioned precedent for the holding that secondhand smoke was indeed a battery. However, it doesn't necessarily reverse that holding on the substance. So we may actually be able to cautiously use this case as a type of persuasive authority, as long as we're really clear about what we're doing. After all, even though, the holding has no legal effect, after the reversal, it wouldn't be considered to be mandatory authority. We don't actually have any reason to believe that the court's analysis of the battery claim in that prior case, was bad analysis or somehow misguided on that aspect of the law. It's just now inapplicable due to the later reversal on workman's comp. So if we really like the analysis, we might cite it in a brief, but include maybe a carefully worded footnote on the reasons for the reversal and why those reasons don't really say anything about the quality of the court's analysis on the battery claim or the soundness of its conclusions for that. Okay, let's look at one more case. This is that easy serve case from our earlier fraud hypothetical. We were interested in this case due to the holding that silence can constitute fraud. If I can find it in the head notes here. Yeah, here we go. Head note 7. And when we pull up this easy serve case, we do see that it has a yellow key site flag, a caution key site flag, telling us that a later court distinguished this case. So ultimately, this might not even end up being that significant. It's certainly not as drastic or consequential as an overruling or a reversal. But still, it's always a good idea to at least go ahead and take a closer look. So we go ahead and click on our key site flag, and it takes us to see all of that negative treatment. And this negative case isn't located under negative direct history. It's located under our negative citing references. And that's different because it just means that a later court cited and analyzed this case, and they came to a negative conclusion or a negative view of the case. But it doesn't necessarily it doesn't mean anything with regards to the actual history of the easy serve case. It has nothing to do with, the litigants in that case or the ultimate outcome of it or the ultimate, legal validity of its holding even. It's just an analysis of this case. So it's definitely going to be, less significant than that negative direct history that we were looking at on the previous case, the pipe smoke case, Henley v. Richardson, or rather Richardson v. Henley. But even though it's not as significant, this can still be really helpful. They can also serve as a sort of warning. If a lot of cases or negative citing references, and if they viewed your case negatively when they analyzed it, even if it was never reversed, it might have, essentially become bad law anyway, just in the sense that it's kind of frowned upon. And a court's not going to want to use it. They're not going to want to reach the conclusions that it reaches. But here we can see that that this Weaver v. Pizza Hut case, it only distinguished our Easy Serve case. That basically just means that, this court didn't apply it because they decided the issue was actually different in some way. So this isn't going to be crucial in terms of the validity of our Easy Serve case, but we know that it could possibly be helpful to our analysis, especially since it's the same court as in Easy Serve that made this distinction. So yeah, you probably want to take a closer look at this case and include it in your research, if it will ever load. Finally, let's just take a quick look at QuickCheck. And what this does is it allows us to just quickly pull all of the negative treatment for all of the sources that you cited in a brief or memo. And just do that all at the same time. You just click on this QuickCheck link from the front page of Westlaw and upload it on this page, or on the Nets page rather. And the process actually takes a few minutes, but I've already done it and pulled it up so that you can at least see the finished product. I don't need to take the tour, but maybe you would want to take the tour. So I went ahead and uploaded our model answer for the sample exam that I posted earlier today in an announcement for you guys. And that way you can at least see what QuickCheck looks like and how it works. So first, it's going to give us a few recommended sources based on our research. And this can be pretty helpful, actually, especially if maybe you're stuck or feel like you're kind of in a dead end with your research, or maybe you're wondering whether you're finished with your research. This will just generate some kind of fresh leads for us based on, what Westlaw's algorithms think might be helpful to us based on what we found so far in our research. But really what we are primarily interested in as far as, updating these sources is the warnings for cited authority tab here. And basically really all this does is it gives you just all of the key cite flags for all of the cases in our memo at once on the same page. You're still going to need to put in the work. You're still going to need to analyze these to determine whether they are actually relevant to the aspects of these cases that relate to our research and our issues. But you've got them all here in the same place, which can make things more convenient for you. And our next tab is quotation analysis, and this can actually be useful. Our brief, or our memo rather, doesn't contain any quotations, but if it did, this next tab would be a nice resource to have to help to ensure that they were indeed accurate quotations. In our next tab, the Table of Authorities tab, that just collects all of the sources that were cited in this memo, and it can be very helpful if you need to create a table of authorities for a brief. You don't need to do that for this course, but it's certainly not an uncommon thing. Okay, let's check out the same stuff on Lexis. Here's our pipe smoke battery case, Richard v. Henley. And we can see here the stop sign signal, which is just Shepard's equivalent of that red flag that we saw on Westlaw. And to find out more, we need to go over to Shepardized document on the sidebar over here. And when we do that, it tells us that our subsequent appellate history contains negative treatment, but we do need to click on that to take a look at it. It's basically the same thing that we saw in Westlaw, although the format is a little different, and it looks like it actually just gives us, all of the appellate history, not only the negative stuff, although that negative analysis does seem to be highlighted here. We look at our fraud by silence case, our easy serve convenience stores. We can see that we have the Shepard's caution signal, and we would just do the same thing. We would go to Shepardize, and you would need to take the extra step here of narrowing our results using these sidebar options to just see that caution signal. But when we do that, it brings up the same case that we saw on Westlaw. Now, the Lexis equivalent of Quick Check is what they call brief analysis. Here's the link to it, which you'll just see from the front page of Lexis. And it mostly has the same functionality, does the same type of things in a similar way. I've put our model answer for the sample midterm into it, just like I did with Westlaw. And we can see most of the same things. We got like a concept map, which is kind of an interesting addition, as well as like the recommended cases that we saw. Again, for the purpose of like updating our case, what we're really the most concerned with are going to be the citations. And we don't get like summaries of the signals and what they mean necessarily, like all in the same document, like we did with Westlaw. But we can investigate them further just by clicking on the signals, and then it'll just pull up the case. So yeah, that is how you determine whether a case is good law. You need to do this consistently, and you need to know that most of the action and most of the work, most of the analysis is going to relate to determining whether the negative treatment actually applies to the case's holding on the issue that you care about. This can require really quite a bit of research on analysis just all on its own, and you need to be prepared for that. Okay, that's all I have for now. Until next time.